I'll never forget the look on Karen Pembroke's face when she strutted into that courtroom, her bleached blonde hair perfectly coiffed, designer handbags swinging with each confident step. She clutched her lawsuit papers like a winning lottery ticket, probably already imagining how she'd brag about this victory at the next HOA meeting. The woman who'd made my life miserable for months was finally going to teach me a lesson about defying her authority. At least, that's what she thought. What she didn't know was that I had my own stack of papers tucked inside my briefcase. Papers that would turn her smug grin into slack-jawed horror. Papers that proved something so absurd, so perfectly ironic, that even I had trouble believing it when I first discovered it. Karen Pembroke, president of the Maple Grove HOA and self-appointed neighborhood dictator, had built her house on my land. But I'm getting ahead of myself. Let me start from the beginning, when I first made the mistake of moving into her domain. 6 months earlier, I'd purchased what the realtor called a unique opportunity in the historic Maple Grove subdivision. The corner lot at the intersection of Elm Street and 2nd Avenue had been on the market for nearly a year, and I should have questioned why. The price was reasonable, the location was perfect for my commute, and the 1960s ranch house needed work but had good bones. What could go wrong? I found out exactly what could go wrong the day after I moved in. I was unpacking boxes in my living room when I heard aggressive knocking at my door. Standing on my porch was a woman in her early 50s, wearing what I can only describe as suburban armor. Pressed khakis, a crisp button-down shirt with the HOA logo embroidered on the pocket, and a clipboard that she wielded like a weapon. "I'm Karen Pembroke, president of the Maple Grove Homeowners Association," she announced, not bothering with pleasantries. "I need to speak with you about several violations I've already observed." I hadn't even finished unpacking, and I already had violations? She proceeded to inform me that my moving truck had been parked on the street for longer than the permitted 2 hours, my grass was 1/4 inch above regulation height, and the previous owner's mailbox was not an approved model. She handed me a stack of papers detailing fines totaling $300. "Welcome to the neighborhood," she said with a smile that didn't reach her eyes before marching back to her house, which I now realized was directly behind mine. Over the next few weeks, Karen's visits became a regular nightmare. She fined me for having the wrong color garden hose visible from the street. She measured the distance between my trash cans to ensure they met the HOA's spacing requirements. When I installed new blinds in my front window, she issued a violation because they were off-white instead of pure white. The breaking point came when she sent me a certified letter demanding payment of 6 months of back HOA dues, plus late fees, totaling $2,400. According to her, the previous owner had stopped paying, and as the new owner, I was responsible for the debt. When I tried to explain that I'd review my closing documents to verify this claim, she interrupted me. "There's nothing to review," she said, standing on my porch with her arms crossed. "Every homeowner in Maple Grove is required to pay HOA dues. It's not optional. If you continue to ignore your responsibilities, I'll have no choice but to place a lien on your property." That night, I pulled out my closing documents, determined to understand exactly what I'd gotten myself into. I spread everything across my dining room table: the deed, the title report, the survey, and various other papers I'd barely glanced at during closing. That's when I found something odd. Attached to my deed was a document I'd overlooked before, a land lease agreement dated July 15, 1973. According to this agreement, my property included not just the corner lot I'd purchased, but also a lease for an additional strip of land that extended beyond my property line. The lease had been paid in full for 99 years as part of some long-forgotten development deal. Curious, I dug deeper into the county records online. What I discovered made me sit back in my chair, stunned. The land lease wasn't just for some random strip of grass. According to the original survey maps, it included a significant portion of what was now the adjacent lot. Karen's lot. The next morning, I visited the county recorder's office and spent hours researching property records. The helpful clerk, an older gentleman named Harold who'd worked there for 30 years, helped me piece together the story. Back in the 70s, a developer had owned several parcels in what would become Maple Grove. To finance the development, he created some creative property arrangements, including long-term land leases. "Oh, I remember this mess," Harold said, adjusting his glasses as he looked at the documents. "There was quite a dispute about it back in the 80s. The developer went bankrupt, properties got sold off piecemeal, and nobody properly resolved these lease agreements. The city just kind of forgot about them. According to the records, when Karen's house was built in 1991, it was constructed partially on land covered by my lease. The back 20 feet of her lot, including a portion of her house, sat on land that I technically controlled through the lease agreement. Armed with this information, I consulted with a real estate attorney named David Lawson. He spent 2 weeks reviewing everything and confirmed what seemed impossible. The lease was still valid and binding. Karen's house was partially built on land that I controlled. "This is one of the most unusual situations I've seen," David told me. "Technically, she's been trespassing for over 30 years. You could demand rent, or even technically demand she remove the encroaching structure." I wasn't interested in destroying someone's home, but I did want Karen to stop harassing me. When she sent another threatening letter about the HOA dues, now claiming I owed $3,000 with additional penalties, I decided it was time to respond. I had David draft a letter explaining that my property was exempt from HOA membership due to its unique status and the pre-existing lease agreements. We also mentioned, almost casually, that we discovered some boundary issues that would need to be addressed. Karen's response came within 24 hours. She showed up at my door, red-faced and waving the letter. "How dare you try to weasel out of your obligations with some made-up technicality?" she shouted. "I don't care what some lazy lawyer says. You live in Maple Grove, you pay dues like everyone else." I remained calm, which seemed to infuriate her more. "Karen, I suggest you have your attorney review the documents we referenced. This isn't a technicality. It's a legal reality." "We'll see about that," she spat. "I'm filing a lawsuit first thing Monday morning. You'll pay those dues plus every legal fee I incur teaching you this lesson." True to her word, I was served with lawsuit papers the following week. Karen was suing me for unpaid HOA dues, late fees, legal costs, and intentional infliction of emotional distress upon the HOA board. The lawsuit demanded over $10,000. I met with David to prepare our response. We decided not to reveal our full hand immediately. Our initial response simply reiterated that my property was exempt from HOA membership and requested dismissal of all claims. But we also filed a counterclaim for trespassing and unjust enrichment, seeking compensation for the unauthorized use of my leased land. When Karen's attorney, a young lawyer named Bradley Morrison, received our counterclaim with the attached property documents, things shifted quickly. Within 2 days, he called David requesting an urgent settlement conference. "I don't think my client fully understood the situation," Bradley said carefully during the call that David put on speaker. "Perhaps we could resolve this matter without further litigation." But Karen refused to back down. At the settlement conference, she sat across from me, arms crossed, glaring like I'd personally insulted her entire family. "This is ridiculous," she said. "I've lived in that house for 20 years. You can't just waltz in here with some old paper and claim I'm on your land." David calmly laid out the documents. The original deed, the lease agreement, the survey maps, the county records. Bradley's face grew paler with each page. "Mrs. Pembroke," Bradley said quietly, "these documents appear to be legitimate. Your house is partially built on land leased to Mr. Thompson." "Then the documents are wrong." Karen snapped. "This is obviously some kind of fraud." The mediator, a retired judge named Patricia Chen, reviewed everything carefully. After an hour, she looked at Karen over her reading glasses. "Mrs. Pembroke, I've seen many property disputes in my career. These documents are authentic, properly recorded, and legally binding. You need to consider settling this matter." Karen stormed out of the mediation, declaring she'd rather go to court than give me a penny. Bradley hurried after her, and I could hear him trying to reason with her in the hallway. 3 months later, we finally had our day in court. Karen entered the courtroom like she owned it, wearing her best suit and her HOA president pin prominently displayed. She sat at the plaintiff's table, shuffling through her papers and occasionally shooting me dirty looks. Judge Robert Hamilton, a no-nonsense man in his 60s, reviewed the case files with obvious interest. When it came time for arguments, Karen's attorney went first, making the case that I was a delinquent homeowner trying to avoid my responsibilities through technicalities. Then it was our turn. David methodically presented our case, showing how my property predated the HOA, how the lease agreement specifically exempted the land from any future homeowners associations, and finally, the bombshell about Karen's house sitting on my leased land. The judge examined the survey maps carefully, comparing them to current satellite images on his laptop. The courtroom was silent except for the sound of papers rustling. "Let me make sure I understand this," Judge Hamilton said slowly. "Mrs. Pembroke's house, the house from which she conducts HOA business, is partially built on land leased to Mr. Thompson?" "That's correct, Your Honor," David confirmed. The judge turned to Karen. "Mrs. Pembroke, were you aware of this when you purchased your home?" Karen's face had gone from red to white. "No, Your Honor. This is the first I'm hearing of it." "And yet you've been collecting HOA dues and issuing fines to neighboring properties for 30 years? The HOA was established legally." Karen protested. "We have proper documentation." "Documentation that doesn't supersede prior property rights," the judge noted. He spent another 10 minutes reviewing the materials before making his ruling. "I find in favor of the defendant, Mr. Thompson. His property is clearly exempt from HOA membership based on the pre-existing agreements. The plaintiff's claims are dismissed with prejudice." But he wasn't done. "Furthermore, regarding the counterclaim, I find that Mrs. Pembroke has indeed been unjustly enriched by the unauthorized use of the defendant's leased land. While I won't order the removal of the existing structure, given the length of time involved, I am ordering that Mrs. Pembroke pay fair market rent for the use of this land." He calculated the amount based on current land values and the square footage involved. "Mrs. Pembroke, you are ordered to pay Mr. Thompson $18,000 in back rent for the previous 3 years, which is the statute of limitations for this claim. Additionally, you must pay $400 monthly going forward for the use of his land, with annual adjustments for inflation." Karen stood up so fast her chair tipped backward. "This is outrageous. I'm not paying rent for my own property." "It's not your property, Mrs. Pembroke," the judge said sternly. "And I'd watch your tone in my courtroom. Consider yourself fortunate that Mr. Thompson isn't seeking to have the encroaching portion of your house removed." But the judge still wasn't finished. "One more thing. It's come to my attention during this proceeding that you've been harassing Mr. Thompson with spurious fines and violations. This behavior stops immediately. Any further harassment will be considered violation of this court's order and will be dealt with accordingly." Karen's mouth opened and closed like a fish out of water. She looked at her attorney, who was already packing up his briefcase with a defeated expression. As we left the courtroom, I heard Karen on her phone, her voice shrill with panic. "Emergency board meeting. Tonight. No, it can't wait until Tuesday." 2 weeks later, I received 2 letters. The first was a check for $18,000 from Karen's attorney, along with a rental agreement for the land use going forward. The second was from the Maple Grove HOA board, informing me that Karen Pembroke had resigned as president effective immediately. I learned from neighbors that the board had voted her out after learning about the lawsuit and the embarrassment she'd brought to the HOA. Her reputation in the community was destroyed. The woman who'd ruled the neighborhood with an iron fist was now the subject of gossip and ridicule. The final irony came when I saw a moving truck at Karen's house 6 months later. She couldn't stand living next to me, paying me rent every month, being reminded of her humiliation. She sold the house at a significant loss because she had to disclose the land lease issue to potential buyers. The new owners, a young couple named the Johnstons, are lovely people. They pay their land lease fee promptly each month, and we get along great. They even invited me to their housewarming party. As for Karen, I heard she moved to a new development across town. One without an HOA. I guess she learned her lesson about the importance of reading property documents carefully. And every January, when I receive that land lease payment, I remember the day Karen Pembroke learned that sometimes the person you're trying to push around might just own the ground beneath your feet.